Marco van Huigenbos and George Janzen, guilty of mischief from their participation of the Coutts border blockade, were sentenced on Friday in front of a packed Lethbridge courthouse. Van Huigenbos was sentenced to 120 days incarceration, while Janzen was given 90 days conditional and 100 hours of community service. He is also barred from visiting the towns of Coutts and Milk River. Their defense lawyers spoke with media immediately after the verdict with their thoughts.
You guys must be happy with how it went today.
Well, we're very pleased with the outcome in one way. We're pleased that Mr. Janzen avoided a sentence of actual imprisonment. We're pleased that he received a conditional sentence of a short duration. And we're also pleased that in this case, and it's something I haven't seen in my career at least, that Mr. Janzen did not receive any house arrest. He didn't receive a curfew. And we think that's a very good outcome for him.
So it will be house arrest or not? You don't know that?
No, there's no house arrest.
So serving in the community, which means he just just doesn't leave the area.
He's subject to the conditions that were set out in court today.
Plus the 100 hours of community service.
Correct.
How did your client react?
I think he's probably relieved.
How important was his statement yesterday?
Well, you heard from Justice Yamushi. His statement was one of the two mitigating factors that really set him apart. And he expressed remorse to the residents of Milk River and to the residents of Coutts. He didn't express remorse for his beliefs, but he did express sorrow for the inconvenience and the harm he caused to those residents.
You think we'll see him before the courts again?
I doubt it.
No, I think it's. I reiterate Alan's statement. I believe Mr. Janzen at this point is relieved, but from our discussion, it seemed to be mixed feelings. Nonetheless, I can also repeat the fact that I have also never seen a CSO that did not contain some sort of curfew or house arrest condition. So for that reason, I'm certainly pleased as well.
His pre-sentence report sounded like it was glowing.
Yes, I can confirm that.
Thank you, gentlemen. Your thoughts? Disappointed?
The sentence is the sentence. There was a range that this justice had, a range that hasn't been set in Alberta. So he's not got any guiding precedent. So all counsel provided him protest blockade decisions from across the country in various contexts, and he found that none of them essentially were on point. He then turned to two transcripts from the Court of King's Bench and the Alberta Court of Justice on sentencing two very different situations, in my view, but he also found that the Crown is immune, which is interesting at law with respect to being considered on sentence. The failure to charge any several hundred principal offenders and nothing happened to them, but individuals whom he found are less culpable than the principal offenders are to be treated differently because of some form of Crown immunity. That is problematic in my view, but the sentence is what the sentence is. And, you know, as we talk about before the court in the last couple of days, the rule of law is the rule of law. The remedy here is to go to the Court of Appeal if you don't like what happened, and the court will consider whether or not to grant a remedy, including bail pending appeal or any other such pre-appeal remedy, and that's how these things are dealt with.
So you're going to appeal it?
It's something for him to decide if he'd like to. You have 30 days to appeal both the trial decision on the finding of guilt as well as the sentencing decision. It's something I'm sure he'll think about.
How did he react?
Of course he's disappointed. I mean, at the end of the day, it was always understood that jail was on the table. The Crown was seeking 9 months in jail, again unprecedented, but so is this unprecedented. For example, the largest sentence that I could find ever handed down for a large blockade protest was 90 days, and that individual kept getting arrested and going back to the site of the protest. So there wasn't really much relevant protest law for Alberta because we don't have these sort of things. And so I think what he is saying is he's joining up with his colleague Justice Lebrenz and his colleague on yet a lower court, Justice Cranky, and saying this is where we're doing in Alberta. And we'll see. If it's up to the parties to decide whether or not to appeal. They have 30 days to do so. And it'll be at the end of the day, if they do that, it's up to the Court of Appeal to decide whether or not the sentence imposed is demonstrably fit or unfit.
Extended details will be provided on Monday during our next full newscast. For Bridge City News, I'm Landon Hickok.